Good morning. I welcome everyone to this confirmation hearing on the nomination of Judge Brett Kavanaugh.
Mr. Chairman.
To serve as Associate Justice.
Mr. Chairman, I'd like to be recognized for a question before we proceed.
Regular order, Chairman.
Mr. Chairman, I'd like to be recognized to ask a question before we proceed. The committee received just last night, less than 15 hours ago, 42,000 pages of documents that we have not had an opportunity to review or read or analyze.
You're out of order. I'll proceed.
We cannot possibly move forward, Mr. Chairman.
I extend a very warm welcome to Judge Kavanaugh.
We have not been given an opportunity to have a meaningful hearing on this nominee.
Their two daughters.
Mr. Chairman, I agree with my colleague, Senator Harris. Mr. Chairman, we received 42,000 documents that we haven't been able to review last night, and we believe this hearing should be postponed.
I know this is an exciting day for all of you here,
Mr. Chairman,
and you're rightly proud
Mr. Chairman, if we cannot be recognized, I move to adjourn.
The American people
Mr. Chairman, I move to adjourn.
Hear directly from Judge Kavanaugh later this afternoon.
Mr. Chairman, I move to adjourn. Mr. Chairman, we have been denied real access to the documents we need to advise.
Mr. Chairman, regular order is called for.
Which turns this hearing into a charade and a mockery of our norms.
Well,
and Mr. Chairman, I therefore move to adjourn this hearing.
Okay.
This is a mockery and a travesty of justice. This is a travesty of justice. We will not go back. Cancel Brett Kavanaugh. Adjourn the hearing.
Command order. Chuck. There's a motion to adjourn.
We're not in executive session.
Mr. Chairman, I ask for a roll call vote on my motion to adjourn.
Okay.
Mr. Chairman, I move to adjourn. I ask for a roll call vote.
We're not in executive session. We will continue as planned.
Mr. Chairman, may I be recognized, sir? Mr. Chairman, I appeal to the chair to recognize myself or one of my colleagues.
You're out of order.
Mr. Chairman, I appeal to be recognized on your sense of decency and integrity. Even the documents you have requested, Mr. Chairman, even the ones that you said, the limited documents you have requested, this committee has not received. And the documents we have, you, sir, have labeled committee confidential. They should be transparent. This committee, sir, is a violation of even the values I've heard you talk about time and time again. The ideals that we should have. What is the rush? What are we trying to hide by not having the documents out front? What is with the rush? What are we hiding by not letting those documents come out? Sir, this committee is a violation of the values that we as a committee have striven for, transparency. We are rushing through this process in a way that is unnecessary. And I appeal for the motion to at least be voted on.
Mr. Chairman.
At least let's have a vote, because when we wrote you a letter on August 24th
Senator,
asking to have a meeting on this issue, you denied us even the right to meet. So here we are having a meeting. Let's at least debate this issue. Let's at least call this for a vote. I appeal to your sense of fairness and decency, your commitments that you've made to transparency. This violates what you have even said and called for, sir. You've called for documents, you yourself, limited documents. We thought there should be more. We have not received the documents that you have even called for. So, sir, based upon your own principles, your own values, I call for at least to have a debate or a vote on these issues and not for us to rush through this process.
Mr. Chairman. Mr. Chairman, I've heard calls for regular order.
I'd like to respond to Senator Booker. Senator Booker, I think that I respect very much a lot of things you do, but you spoke about my decency and you spoke about my decency and integrity, and I think you are taking advantage of my decency and integrity. So. Okay.
The order, it is regular order for us to receive all the documents, that this committee is entitled to.
Okay.
Mr. Chairman, it is also,
I think that
Mr. Chairman, it is also not regular order for the majority to require the minority to pre-clear our questions, our documents, and the videos we would like to use at this hearing. That is unprecedented. That is not regular order. Since when do we have to submit the questions and the process that we wish to follow to question this nominee?
Senator,
I'd like your clarification. I'd like your response on why you are requesting the minority to submit our questions to you.
I ask that you stop so we can conduct this hearing the way we have planned it. Maybe it isn't going exactly the way that the minority would like to have it go, but we have said for a long period of time that we were going to proceed on this very day, and I think we ought to give the American people the opportunity to hear whether Judge Kavanaugh should be on the Supreme Court or not. And you have heard my side of the aisle call for regular order, and I think we ought to proceed in regular order. There will be plenty of opportunities to respond to the questions that the minority is legitimately raising, and we will proceed accordingly.
Mr. Chairman, under regular order, may I ask a point of order, which is that we are now presented with a situation in which somebody has decided that there are 100,000 documents protected by executive privilege, yet there has not been an assertion of executive privilege before the committee. How are we to determine whether executive privilege has been properly asserted if this hearing goes by without the committee ever considering that question? Why is it not in regular order for us to determine before the hearing at which the documents would be necessary whether or not the assertion of privilege that prevents us from getting those documents is legitimate or indeed is even an actual assertion of executive privilege? I do not understand why that is not a legitimate point of order at this point, because at the end of this hearing, it is too late to consider it.
Mr. Chairman, if I might add to this, on the integrity of the documents we've received, there really is no integrity. They have alterations, they have oddities, attachments are missing, emails are cut off halfway through a chain, recipients' names are missing. Many are of interest to this committee, but it's cut off. The National Archives hasn't had a chance to get us all that we want, even though you said on your website the National Archives would act as a check against any political interference. But I check after the hearing is over, there's no check. I think we ought to at least have the National Archive finish it, and to have, for the first time, certainly in my 44 years here, to have somebody say there's a claim of executive privilege when the president hasn't made such a claim just puts everything under doubt. What are we trying to hide? Why are we rushing?
I can answer all the questions that have been raised, but I think if I answer those questions, it's going to fit into the effort of the minority to continue to obstruct, and I don't think that that's fair to our judge. It's not fair to our constitutional process. But let me respond to those now, and then maybe we can proceed. My colleagues on the other side are accusing the administration of using executive privilege to hide documents from the committee. I want to say why they're wrong. Unlike President Obama's assertion of executive privilege during Fast and Furious is one example, this assertion is not legitimate. Judge Kavanaugh was a senior lawyer in the White House. He advised the president on judicial nominations, provided legal advice on separation of powers issues, and handled litigation matters. As the Supreme Court has put it, quote, unless the president can give his advisors some assurance of confidentiality, a president could not expect to receive the full and frank submissions of facts and opinions upon which the effective discharge of his duties depends, end of quote. The issues Judge Kavanaugh worked on are exactly the sort of issues that require, according to the Supreme Court, some assurance of confidentiality. We in the Senate and everyone else in America expect exactly the same sort of confidentiality. Most senators would not agree to turn over their staff's communication to anyone. For example, we didn't ask that Judge Kagan's records for her service with then Senator Biden be turned over during her nomination. And because of attorney-client privilege, everybody has a right to keep communications from their lawyers out of government hands. We therefore didn't ask for Justice Ginsburg's documents from her time with the ACLU. We didn't ask for Judge Sotomayor's confidential documents from her time in private practice. It can't be that the Senate and the ACLU are entitled to more protection than the President of the United States. And then I will speak to the fact about 42,000 pages. Last night, we received additional documents for the committee's review. These were documents we requested before the hearing, and we received them before the hearing just as we requested. The majority staff began reviewing the documents as soon as they arrived and has already completed its review. There is thus absolutely no reason, that's no reason to delay the hearing. We have received and read every page of Judge Kavanaugh's extensive public record. This includes 12 years of his judicial service on the most important federal circuit court in the country, where he authored 307 opinions and joined hundreds more, amounting to more than 10,000 pages of judicial writing. We also received and read more than 17,000 pages of his speeches, articles, teaching materials, other documents that Judge Kavanaugh submitted with his questionnaire, the most robust questionnaire this committee has ever issued. And of course, we received and read more than 483,000 pages of documents from Judge Kavanaugh's extensive executive branch service. This is more pages than the last 5 Supreme Court nominees combined. In short, this committee has more materials for Judge Kavanaugh's nomination than we have had on any Supreme Court nominee in history. Senators have had more than enough time and materials to adequately assess Judge Kavanaugh's qualifications, and so that's why I proceed. I know that this is an exciting day for all of you in the family and all the people that are close to Judge Kavanaugh, and you're rightly proud of the judge. The American people get to hear directly from Judge Kavanaugh later this afternoon. After this confirmation hearing and process is finished, I expect Judge Kavanaugh will become the next Associate Justice of the Supreme Court. Welcome again, Judge. Before I begin, I would want to give you, Judge, an opportunity to introduce your family.
Thank you, Mr. Chairman and Senator Feinstein. And
push the red button if it's not on.
Will we have opening remarks?
Yes, we're going to have. Yeah.
Thank you, Mr. Chairman and Senator Feinstein and members of the committee. I'm honored to be here today with my family, my wife, Ashley, proud West Texan, graduate of Abilene Cooper High School, now the town manager of our local community where we live. Our daughters, Margaret and Liza. Thank the committee for arranging a day off from school today. My mom and dad, Martha and Ed Kavanaugh, my aunt and uncle, Nancy and Mark Murphy, and my first cousins, Rosie and Elizabeth Murphy. I'm very honored to be here, honored to have my family here. I'm here because of them. Thank you, Mr. Chairman.
We're delighted to have your family here. Before I make my opening remarks, I want to set out the ground rules for the hearing. I want everyone to be able to watch the hearing without obstruction. If people stand up and block the view of those behind them or speak out of turn, it's not fair or considerate to others, so officers will immediately remove those individuals, and I thank the officers for doing the work that they have to do. We'll have 10-minute rounds of opening statements with each member. The ranking member and I may go a little over 10 minutes, but I'm going to ask everyone else to limit your remarks to those 10 minutes. I hope everyone will respect that. We plan on taking a 15-minute break after Senator Cruz's opening statement. After all the opening statements by senators are complete, we'll take another 15-minute round break to turn to our introducers, who will formally present the judge. After that, I'll administer the oath to the judge, and we'll close that portion of today's hearing with his testimony.
Mr. Chairman, when will we review Senator Blumenthal's motion to adjourn?
What's your question?
I renew my motion to adjourn, Mr. Chairman. I think we're entitled to a vote on it.
Yeah.
The responses that, Mr. Chairman, you've given with all due respect really fly in the face of the norms of this committee, our traditions, and our rules.
Okay. Mr. Chairman, if I might add an additional point, I agree with my colleague. It is striking, given your long history of encouraging the executive branch to treat minority requests equal with majority requests, that you discouraged the National Archives from responding to Ranking Member Feinstein's request, which she tried to craft with you to be identical to the request for records from Justice Kagan. We should not be proceeding until we have the full documents that allow us to review the judge's records.
And Mr. Chairman, last Friday we learned that nearly 102,000 pages of documents from Judge Kavanaugh's work in the White House counsel's office are being withheld from the committee and the public based on a claim of constitutional privilege. Executive privilege has never been invoked to block the release of presidential records to the Senate during a Supreme Court nomination. This includes when Justice Kagan was nominated to the Supreme Court, as well as Justice Roberts. Yesterday, my colleagues and I sent a letter to the White House counsel asking that the president withdraw his claim of privilege over these documents so that they can be made available to this committee and to the American people. We have not yet received a response to that letter, so we should not be proceeding until we have a response and these documents have been available. It is 102,000 documents.
And Mr. Chairman,
my motion to adjourn, Mr. Chairman, would raise this issue of executive privilege and whether it has been properly asserted for reasons that have been outlined well by my colleague, Senator Whitehouse. There is no valid claim here of executive privilege. Even if there were one, it has not been properly asserted. The question is, what is the administration afraid of showing the American people? What is it trying to hide?
And Mr. Chairman, using your own words in the statement you just read, you said, I quote, "We've had more than enough time to review the documents." Sir, we just got a document dump last night of over 40,000 pages. I would venture to say not one senator here has had time to read through those 40,000 pages. And so we are continuing to rush through this process, a process that deserves to be scrutinized. I support Senator Blumenthal's motion to adjourn, and I hope that we could at least have a vote on that motion.
Mr. Chairman, I think you'd be hard-pressed to find a court in the country that would not give a party litigant a continuance when the party on the other side did a 42,000-page document dump after close of business the night before trial?
Mr. Chairman, we waited for more than a year with a vacancy on the Supreme Court under the direction of your leader in the United States Senate, and the Republic survived. I think the treatment was shabby of Merrick Garland and President Obama's nominee. The fact that we cannot take a few days or weeks to have a complete review of Judge Kavanaugh's record is unfair to the American people. It's inconsistent with our responsibility under Article 2, Section 2 of the Constitution to advise and consent on Supreme Court nominees.
Senator Cornyn, you want to speak?
Mr. Chairman, thank you. I'll be very brief. I would just say that Senator Whitehouse has suggested that we handle this hearing like a court of law. But I would suggest that if this were a court of law, that virtually every side, every member of on the dais on that side would be held in contempt of court.
Oh, come on.
Because this whole process is supposed to be a civil one where people get to ask questions and we get to get answers. And that's the basis upon which we are to exercise our constitutional responsibilities of advice and consent. So I would just suggest we get on with the hearing.
If my colleagues...
Mr. Chairman, I could just respond. Mr. Chairman, if I could just respond.
Mr. Chairman.
If we could just respond to that.
I would...
Sir.
You can respond, but just a minute. If people wonder why the chair is so patient during this whole process, I have found that it takes longer to argue why you shouldn't do anything than let people argue why they want it. These things are going to be said throughout this hearing. We're going to be in session Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, till we get done this week. So however long people want to take, we're going to not necessarily accommodate all obstruction, but if people got something to say, this chairman's going to let them say it. But it gets pretty boring to hear the same thing all the time. Senator Booker, make it quick, please.
I really appreciate the deference, Mr. Chairman. The question was why would we want to delay this? And this is not an attempt to delay. This is an attempt to be fully equipped to do our constitutional duty, which everybody, Republicans and Democrats on this committee, take seriously. It is very hard to perform our role of advice and consent when we do not have a thorough vetting of the background of the candidate in areas which the candidate himself has referred to as the most formative part of his legal career, where he himself has talked about how important this period of his life is. We're denied the full vetting. And, sir, this is not something that Democrats are asking for. I remind you that you yourself asked for a limited set of documents for when he was in the White House counsel's office. You yourself set that standard. And even on that limited standard, sir, we have not received the documents. And then even the documents, we've received 7% of them. Almost half of those have been labeled committee confidential that cannot be put before the American people, which further undermine and inhibit our ability to ask questions to thoroughly vet this candidate and advise and consent the President of the United States. So, sir, just on the basic ideals of fairness, the traditions of this body, we should have a thorough understanding of the nominee that's put before us so that we can vet them. To go into this hearing without those documents is an undermining of the constitutional role to which we have all sworn an oath to uphold.
Mr. Chairman, I have great respect for my colleague from Texas.
I would like to respond to Senator Booker, and then Senator Feinstein has asked for the floor.
Mr. Chairman, I asked to respond to my colleague from Texas. Mr. Chairman.
Senator Booker, using a standard set by two members of your political party in the caucus, and I'm going to phrase because I don't have the exact quotes in front of me, but recently Senator Schumer said from the floor, the best judge of whether or not somebody should be on the Supreme Court is decisions that they've made at lower courts. Senator Leahy said something similar to that when Senator Sotomayor was before us, that We know how many, we know what you have done in a lower court. That's the best basis for knowing whether or not you ought to be on the Supreme Court. So we have 307 cases that this nominee has written decisions on as a basis for that. And we've got 488,000 other pages, and maybe the senators haven't read them, but their staff is fully informed, because last night before 11 o'clock, on the 42,000 pages that have come to our attention, the staff on the Republican side has gone through them.
But, sir, then why did you ask for the White House counsel documents? They were not germane to this hearing. Why would you even ask for them?
Senator Feinstein.
For the record, that's a rate of 7,000 pages per hour. That's superhuman.
Yeah.
They're amazing. They're amazing.
Mr. Chairman,
Yes,
if I
go ahead.
may,
Yeah,
I've been through 9 Supreme Court hearings.
is this your
and
opening statement?
It's part of it.
Why don't you make your opening statement?
Shall I?
Yeah, would you please?
Mr. Chairman, I
There's a
asked for an
motion
opportunity
pending.
to respond to my colleague from Texas because
Please.
he is directly challenged.
I
with-
said you're out of order.
Well, Mr.
Senator
Chairman,
Feinstein.
I ask in the process
Would
of
you-
regular order
Would
an
you-
opportunity to respond to what I
let
believe
me-
was a personal attack.
I'd like to have you give Senator Feinstein the courtesy of listening to her opening statement.
Well, I was just going to say some things. And you heard that this is my 9th hearing. And I think we've got to look at this. These are very unique circumstances. Not only is the country deeply divided politically, we also find ourselves with a president who faces his own serious problems. Over a dozen cabinet members and senior aides to President Trump have resigned, been fired, or failed their confirmations under clouds of corruption, scandal, and suspicion. The president's personal lawyer, campaign manager, deputy campaign manager, and several campaign advisors have been entangled by indictments, guilty pleas, and criminal convictions. So it's this backdrop that this nominee comes into when what we're looking at is he within the mainstream of American legal opinion, and will he do the right thing by the Constitution? We are also experiencing the vetting process that has cast aside tradition in favor of speed. When Justice Scalia died, Republicans refused to even a meeting in their office with President Obama's nominee, and held the seat open for 1 year. Now, with a Republican in the White House, they've changed their position. The majority rushed into this hearing and is refusing to even look at the nominee's full record. In fact, 93% of the records from Kavanaugh's tenure in the White House as counsel and staff secretary have not been provided to the Senate, and 96% has not been given to the public. We do know what the White House thinks of this nominee. Don McGahn, the White House counsel, spoke to the Federalist Society and made clear Brett Kavanaugh is exactly the kind of nominee the president wanted. In his speech, Mr. McGahn discussed President Trump's 2 lists of potential Supreme Court nominees. One, he said, was filled with mainstream candidates. The other list included candidates that are kind of too hot for prime time, the kind that really would be really hot in the Senate. Probably people who have written a lot. We really get a sense of their views, the kind of people that make people nervous. That's a quote. Now, what I'm saying, this is the backdrop into which we come into this situation. So, yes, there is frustration on this side. We know what happened with the prior nominee, the last one President Obama presented to us. He never even got a meeting. He never got a hearing. He never got a vote. And now the rush to judgment and the inability to really have a civil and positive process ends up being the result. I really regret this, but I think you have to understand the frustration on this side of the aisle. Everyone on this side of the aisle wants to do a good job. They want time to be able to consider what the findings are. And there are tens of thousands of pages of emails and other items which could constitute findings on a whole host of major subjects that this nominee may be faced with. And they're serious. The torture issues, all of the Enron issues that he's been through, all of the kinds of things that we want to ask questions about. So, I mean, understand where we're coming from. It's not to create a disruption. It's not to make this a very bad process. It is to say, majority, give us the time to do our work so that we can have a positive and comprehensive hearing on the man who may well be the deciding vote for many of America's futures.
Mr. Chairman, I renew my motion to adjourn and Senator Harris's motion to postpone. I ask for a second.
Second the motion.
Mr. Chairman, I ask for a vote.
Yeah.
I ask that we reconvene an executive session
I
and have a
shouldn't have
vote.
to explain to you, we're having a hearing. It's out of order. We're not in executive session. That'd be the proper forum for entertaining motions.
I ask that we reconvene an executive session. We
won't vote on Senator Blumenthal's suggestion. We won't follow your suggestion.
Well, it's a motion, Mr. Chairman.
To go into executive session. Motions would not be proper at this time.
Mr. Chairman, it's a pending motion before the committee.
Yeah.
Mr. Chairman, if there is no vote on this motion, which has been properly seconded and which could be given a vote in executive session, this process will be tainted and stained forever. I'm asking as a member of this committee, it's my right to do so, that we vote on my motion to adjourn and Senator Harris's motion to postpone, and that we do it in executive session, which can be easily and quickly convened right now.
Yeah. The motion is out of order.
Sir, then I make a very clear and simple motion to move into executive session so that Senator Blumenthal's motion may be considered.
The motion is out of order.
Well, they're not out of order, Mr. Chairman. They're properly before this committee. Simply saying so, with all due respect, and I have great respect for the chairman, doesn't make them so. It doesn't make them out of order just because the chairman rules that they're out of order. We have a number of excellent lawyers in this room, and I ask that this body now do what its responsibility is, to have an executive session so we can vote on a motion to adjourn, and then we can deliberately and thoughtfully consider the documents that have been presented and also review the committee documents that have been marked confidential without any reason or rationale.
The motion is denied.
Sir, how long would that take? 10 minutes for us to have a motion and a vote on this process? I don't understand what the rush is that we can't even let senators vote on what is a very important motion germane to our constitutional duties before this body, before we proceed. I don't understand. It won't take that much time. What is the rush? What are we afraid of to hold a vote on the motions before us?
Mr. Chairman. Mr. Chairman.
Senator Kennedy.
Thank you, Mr. Chairman. I have a question about the process. I understand my colleague's point, and I understand they feel strongly about this. But what are going to be the ground rules today? Are we going to be allowed to interrupt each other, interrupt a witness? Yeah. Are we going to, should we seek recognition from the chair? I just want to understand the ground rules.
Proper respect and decorum, plus how we normally have done business in a hearing like this. We wouldn't be having all these motions. You're new to the Senate, so this is something I've never gone through before in 15 Supreme Court nominations that I have been since I've been on here. And every member, I was interrupted before I got a chance to say what the agenda for today, but every member is going to get 10 minutes to make their remarks, and then we will go to the introducers of Judge Kavanaugh. There will be 3 of those. They will take the usual time of introducers, and then we will have the swearing in of Judge Kavanaugh, and then we will have his opening remarks, and then we will adjourn for today. We'll reconvene at 9:30 on Wednesday and Thursday. Each member will have 30 minutes to ask questions or make all these points they're making right now for the first round. Then there will be a second round of 20 minutes each. So every member is going to get 50 minutes to ask all the questions or make all the statements that they want to make in regard to anything about this candidate or anything about how this meeting's being conducted. And then we will go late into Wednesday night or Thursday night till we get done with the questioning of Judge Kavanaugh. And then on Thursday, we're going to have 3 panels of 6 each, evenly divided for people that think Judge Kavanaugh should be on the Supreme Court and people that think he should not be on the Supreme Court. And we hopefully get that done Friday, but if we have to go Saturday and Sunday, we'll go Saturday and Sunday until we get it all done.
Mr. Chairman, how can we possibly
Does that answer your question, Senator Kennedy?
Well, if I want to, yes, Mr. Chairman, I appreciate it. If I want to say something, do I need to be recognized by the chair?
That would be the way that it's handled. I've tried to explain to you, I'm going to be patient, because sometimes if you aren't patient and you argue why something shouldn't be done, it takes longer than it does just to listen to people. But I don't think we should have to listen to the same thing 3 or 4 times.
Well, patience is good, Mr. Chairman. But I just want to understand the rules. If I want to be recognized...
Yeah, you should be recognized. You can understand that I have been patient and listened to people not be recognized and speak anyway, because I would like to have this be a peaceful session.
Well, before I try your patience, I'm done.
Mr. Chairman, I have a question about ground rules.
Go ahead.
The question is, before we can proceed, I'd like to know whether the majority is still requiring of all of the Democratic members of this committee to pre-clear the questions, documents, and videos that we would like to use at this hearing.
I was hoping that on the subject that you just brought up, that we would have some clarification of what you want to approach that. And I'm not prepared to answer that question because I don't know what the answer has been, and I don't want you to give me what you think the answer has been of discussion between our staff on that subject.
Mr. Chairman, I don't think it's ever been the case in a hearing like this that the members of this committee have to pre-clear what we propose to query the nominee about. I think that is totally unprecedented.
And Mr. Chairman, if we don't even know what the rules are, how can we proceed with this hearing?
I'd like to respond to Senator Hirano. The reason why we're having that discussion is, at least in my time on this committee and for 15 nominations, we've never had a request for a video. So it seems to me, to be courteous to all the members of the committee, it'd be nice to know the purpose and what it might contain. Any questions you want to ask, you can ask questions. It isn't about what questions you were going to ask. It's about the presentation of something that's never been a part of a Supreme Court hearing in the past.
Mr. Chairman.
Who wanted?
Mr. Chairman.
Yes. I think I'll go back and forth. Senator Tillis.
Mr. Chairman, I'm confused because I heard earlier that this was a reaction to the document releases last night, but I'm reviewing a tweet from NBC that said Democrats plotted coordinated protest strategy over the holiday weekend, all agreed to disrupt and protest the hearing, sources tell me. And subsequent Dem leader Chuck Schumer led a phone call, and committee members are executing now. So I just want to be clear, none of the members on this committee participated in that phone call or that strategy before the documents were released yesterday. Are you suggesting that this allegation is false?
Chairman, may I
This is
respond?
outrageous.
Senator Durbin.
Mr. Chairman, there was a phone conference yesterday, and I can tell you at the time of the phone conference, many issues were raised. One of the issues was the fact that over 100,000 documents related to Judge Kavanaugh have been characterized by the chairman of the committee as committee confidential. I've been a member of this committee for a number of years. Committee confidential documents have been really limited to extraordinary circumstances. As an example, if someone is accused of taking drugs during the course of an investigation, and I'm not making any suggestion that that is even the case or close to it here, it was done in a confidential setting, in fairness to the nominee. And the same thing on DUIs and the like. We used it in extremely rare circumstances where we would meet after this committee hearing and sit down, and it usually related to a handful of pages or a handful of document references. Instead, what we found now is that we are seeing hundreds of thousands of documents characterized as committee confidential unilaterally. It's not done on a bipartisan basis. It's being done by the chairman. So one of the discussions yesterday was this whole question of whether this committee is going to hear a nominee for a lifetime appointment to the highest court in the land without access to basic information about his public record. His public record as Secretary to the President of the United States, Staff Secretary. 35 months of public service, we've been told, cannot even be considered. The documents of that service cannot even be considered. So I'd say to the gentleman, or the senator from North Carolina, there was a conversation yesterday about these documents. I had no idea that at 11 o'clock last night, 42,000 more documents would be put on top of us, and we'd be asked to take them up today. So it added insult to injury.
Mr. Chairman,
Chairman, I ask to be recognized under Rule 4. Rule 4 states, the chairman shall entertain a non-debatable motion to bring a matter before the committee to a vote. If there is objection to bring the matter to a vote without further debate, a roll call of the committee shall be taken, and debate shall be terminated if the motion to bring the matter to a vote without further debate passes with 11 votes in the affirmative, one of which must be cast by the minority. I ask for a vote on my motion to adjourn under Rule 4, Mr. Chairman. These are rules that we are obligated to follow. The chairman has no right, with all due respect, to simply override them by fiat.
Yeah. We are obligated. We're obligated by that rule in executive session. We're not in executive session. I would respond. I would respond to the issues brought up by Senator Durbin about confidential documents. I was criticized for my decision to receive some documents on committee confidential, but I'm doing exactly what I did during Judge Gorsuch's confirmation and what Chairman Leahy did during Justice Kagan's. This is another example of treating regular committee practices as somehow out of the ordinary. Presidential records that we receive often contain highly sensitive advice to the president, as well as personal privacy information like full names, date of birth, Social Security numbers, and bank account numbers. Like my predecessor, I agreed to receive some presidential records as committee confidential so that both Democrats and Republicans could begin reviewing Judge Kavanaugh's materials much earlier. I don't know why my Democrat colleagues object to receiving documents faster, but not all of these presidential records remain confidential. In fact, nearly two-thirds already became public. These records are posted on the committee's public website and available to the American people. As a result, we provided unprecedented public access to a record number of presidential records and did it in record time. The most sensitive presidential records remain committee confidential under federal law, just as they were during the nominations of Kagan or Gorsuch. But we have expanded access to these documents also. Instead of just providing access to committee members, we provided access to all 100 senators. Instead of just providing access to a very few committee aides, we provided access to all committee aides. And instead of just providing access to physical binders of paper, we provided 24/7 digital and searchable access. This is unprecedented access to committee confidential material. I'd also like to add that my staff set up workstations and have been available 24/7 to help senators who are not on committee access confidential materials, but not one senator showed up. I guess senators complaining about lack of access to confidential documents weren't really interested in seeing them in the first place. But I want to emphasize more documents are widely available than in any prior Supreme Court nomination. And then to the issue about hiding committee confidential documents. Some colleagues, and you've heard it this morning, accuse of hiding documents. They're suggesting that some of the committee confidential documents contain information that would be of great interest to the public. Well, just as I did last year during Justice Gorsuch's confirmation, I put a process in place that would allow my colleagues to obtain the public release of confidential documents for use during the hearing. All I asked was my colleagues to identify the documents they intended to use, and I would work to get the Department of Justice and former President Bush to agree to waive restrictions on the documents. Senator Feinstein secured the public release of 19 documents last year under this process, and Senator Klobuchar secured the release of 4 documents this year. If my colleagues truly believe that other committee confidential documents should have been made public, they never told me about them and request the ones that they wanted. Instead of scaring the American people by suggesting that we're hiding some incriminating documents, they should have made a request that I work to get the committee confidential designation removed. This year, I received no such request except from Senator Klobuchar, which was honored and resulted in the disclosure of documents that she wanted to use during this hearing.
Mr. Chairman, you stated what I did, and you stated it inaccurately. I think I have the right.
I said I was paraphrasing it. Well, you can correct me any way you want to.
It was one heck of a paraphrase when you
give me the
when you speak about doing the same thing as with Elena Kagan. I was chairman when Elena Kagan was here. We had 99% of her records from the White House were made public 12 days before the hearing. With Judge Kavanaugh, we have 7%, and only 4% are public. You can talk about the numbers of pages. The fact is, 99% for Elena Kagan, 12 days before the hearing. It was all available. For Judge Kavanaugh, 7%, and only 4% made public. So, if we're going to argue what was precedent, I would point out that I've been in the Senate for 19 Supreme Court nominations. What is being done here is unprecedented. And I keep coming back to the same question I asked. What are we trying to hide? What are we hiding? What's being hidden? Why not have it open like all others? The only other time we heard a president invoke executive privilege was President Reagan during the Justice William Rehnquist hearing, and Republicans and Democrats together went to him and said, don't do that. And he said, okay, you're right. And he withdrew his request of executive privilege and released the documents.
Mr. Chairman.
I'm just sorry to see the Senate Judiciary Committee descend this way. I felt privileged to serve here under both Republican and Democratic leadership for over 40 years. This is not the Senate Judiciary Committee I saw when I came to the U.S. Senate.
Mr. Chairman, since my name was invoked by you, could I please respond?
After I get done, I want to give the exact quote that I was paraphrasing. Chairman Leahy said, quote, "We have Judge Sotomayor's record from the federal bench. That is a public record that we had even before she was designated by the president. Judge Sotomayor's mainstream record of judicial restraint and modesty is the best indication of her judicial philosophy. We do not have to imagine what kind of a judge she will be because we see what kind of a judge she has been." And so that's why my answer to the gold standard of whether Senator Kavanaugh ought to be on the Supreme Court, based upon what Democrats themselves have said is the best judge of whether you should be on the Supreme Court. Senator Klobuchar.
Well, wait a minute. You mentioned what I said. Let me just finish on that. On Justice Sotomayor, I did say that we should look at her cases just as we should on Judge Kavanaugh's. But you neglect to mention, carefully neglect to mention, and I think erroneously neglect to mention, that the Republicans asked for board minutes from her work at a civil rights group in the 1980s, long before she was ever even considered as a judge. You asked for that, and we got it for you. That's
Mr. Chairman.
Mr. Chairman.
Mr. Chairman, you called on me.
Before Senator Klobuchar speaks, we have 488,000 pages of documents. Go ahead, Senator Klobuchar.
Thank you very much, Mr. Chairman. Few points here. Number one, Justice Sotomayor never worked in the White House, so none of these issues of executive privilege or other things that we've been discussing are relevant. Number two, while I appreciate you granting my request, Mr. Chairman, on these campaign finance documents, this is all they were. This is it. This is how many pages. Yet we have 148,000 documents that we can't talk about publicly. And I will say they are illuminating. It shows that the nominee has a limited view of campaign finance reform. In his own words, he says that his views on the First Amendment are pure when it comes to this very important issue. And we can talk about that more in the future. But I do have a question, and that is that, yes, I asked for these documents, but I've also joined several letters led by Senator Feinstein asking that all the documents that we have in the committee be made public so that we can ask questions. And then finally, on my initial point that I'm so focused on, the 102,000 pages of documents from Judge Kavanaugh's work in the White House Counsel, I would like to know, Mr. Chairman, if you have another example of a time when executive privilege was invoked to block the release of presidential records to the Senate during a Supreme Court nomination. As far as my research shows, this wasn't done for Justice Kagan or Justice Roberts, and I'd like to know if you have another example of that during a Supreme Court nomination hearing.
Yeah, it was done for Justice Roberts, and it was the Solicitor General position he had. Senator
When he was a Solicitor General, that is correct, but during the time that they worked in the White House. That is my question.
Mr. Chairman, I'd like to bring you the attention of the chair.
I believe I had the floor.
Senator Cornyn.
Thank you, Mr. Chairman, for recognizing me. I haven't been in as many confirmation hearings as some of my colleagues, but this is the first confirmation hearing for a Supreme Court justice I've seen, basically, according to mob rule. We have rules in the Senate. We have norms for decorum. Everybody, as you pointed out, Mr. Chairman, is going to get a chance to have their say. Yeah. You've given everybody a chance to ask questions for up to 50 minutes. You've given them a chance to make an opening statement. Any one of our colleagues can step out here and talk to the press and make whatever comments they want to the press and tell the world how they feel about this. But the fact is, it's hard to take it seriously when every single one of our colleagues in the Senate Judiciary Committee on the Democratic side have announced their opposition to this nominee even before today's hearing. So it's hard to take seriously their claim that somehow they can't do their job because they've been denied access to attorney-client or executive privilege documents when they've already made up their mind before the hearing. There's nothing fair about that. And we would just ask for an opportunity for the American people to be able to listen to this nominee answer the questions that we have.
And I think that's how we ought to proceed, and I hope we will.
Mr. Chairman, can I be recognized to respond specifically to that comment? There is precedent here. There are rules that can guide us. We're asking for those rules to be followed. In the past, our colleagues on the Republican side have asked for a postponement of these committee proceedings on nominations when documents have been denied on 2 occasions from Senator Sessions, then Senator Sessions, and Senator Kyle. Those requests were granted. We're asking simply that that precedent be followed, Mr. Chairman. Far from mob rule, far from contempt of the process, we're simply asking for respect here to the normal, regular order.
Mr. Chairman.
Yeah, go ahead.
Mr. Chairman, I'd like to address this committee confidential issue one more time because you've explained your point of view. Here's what we know. The Chairman Grassley, who's my friend and I respect, said his reason for unilaterally designating 147,000 pages of Burke documents as committee confidential is because that was the condition that Bill Burke imposed on the provision of the documents. When Judge Kavanaugh was in my office, meeting with us, I asked him, who is Bill Burke? By what authority can he restrict the information given to the Senate Judiciary Committee and to the American people? Is he a government employee? No one knew. This mysterious Bill Burke who is filtering these documents. So I figured since the nominee carries the Constitution in his pocket, there must be some reference to Bill Burke in Article 2, Section 2, but it just says advice and consent of the Senate. It doesn't include Mr. Burke. By what authority is this man holding back hundreds of thousands of documents from the American people? Who is he? Who's paying him? So committee confidential is being determined by a man, a private attorney, and we don't know who he works for or who he's accountable to. Mr. Chairman, in the past, when we went into committee confidential, it was in a discrete, specific area of concern involving a handful of words or accusations that had been made in a document, and we were very careful to do it on a bipartisan basis. That has not been the case here, where 147,000 pages have been designated by Bill Burke as outside the reach of the American people in the Senate Judiciary Committee. That's a further example of why this whole process has gone astray. And I think your explanation ignores that.
Mr. Chairman. Mr. Chairman.
Who wants the floor?
The new senator.
Go ahead.
Thank you, Mr. Chairman. Mr. Chairman, can you tell me again how many documents have been produced?
488,000 minus, or I mean, other than 28,000 pages that Justice Kavanaugh has submitted, including his own judicial opinions.
Number 2, are we in executive session or not?
We're having a hearing on the nomination of a nominee for the Supreme Court.
Yes, sir, I got it.
We're not in executive session.
All right. Number 3, at some point, are we going to get to hear from the nominee?
Hopefully, it was going to be before 2:30. It'll probably be later this afternoon now.
All right. Thank you, Mr. Chairman.
Yeah.
Mr. Chairman.
Can I ask my colleagues on the other side of the aisle how long you want to go on with this? Because I'm not going to entertain any of the motions you're making. We're not in an executive session, and I think we ought to level with the American people. Do you want this to go on all day? Because I have been patient. I've been accused of having a mob rule session. Now, if we have a mob rule session, it's because the chairman's not running the committee properly. But since every one of you on that side of the aisle, except Senator Booker, Senator Harris, new to the committee, said during Justice Gorsuch's hearing, every one of you prefaced your comments on how fair I was in running that hearing. Now, this is the same Chuck Grassley that ran the Gorsuch hearings. I'd like to run this hearing the same way if you'll give me the courtesy of doing it.
Thank you, Mr. Chairman.
How long do you want to go on?
Mr. Chairman, I'd like to make one more point before we proceed, if I might.
Senator Coons.
The accusation that this is a mob rule hearing was made by your colleague from the state of Texas. I think you have been conducting this in a respectful, appropriate, and deliberate way. My concerns that I want to renew, given the exchange you just had with Senator Leahy, who has participated in or presided over more Supreme Court confirmations than any currently serving member, I believe, was over how the document request was handled for now Justice Kagan. a request was sent to the National Archives. Ranking Member Feinstein tried to work with you to send an identical request to the National Archives. And before we proceed with the questioning, Mr. Chairman, I simply would like to have a settled heart about why you chose to communicate directly to the archives, not to respond to the ranking member's request. Members of this committee have raised issues about an unprecedented committee process by which documents were blocked, by which they were considered classified, and by which we have been blocked from being able to share them with the American people or ask questions based on them. This is unprecedented. That's why, as you put it, this side seeks to raise issues to establish ground rules before we proceed.
You've asked an appropriate question. I have an answer. I don't know whether it will satisfy you or not. Those documents are the least useful in understanding his legal views and the most sensitive to the executive branch. And let me emphasize the most sensitive to the executive branch. The staff secretary serves as an inbox and outbox to the Oval Office. And if you're going to have opportunities to ask the nominee himself what he did then, but I'm giving you my judgment about being a person that primarily was responsible for managing the paper that crosses the president's desk. His job, and if I'm wrong, he can satisfy you otherwise in your questions you wanted to ask him, but his job was to make sure the president sees the advice of other advisors, not as staff secretary providing his own advice. One of President Clinton's staff secretaries, Todd Stern, described the job this way. I quote, "The staff secretary's job is not to influence the president, but to ensure he gets a balanced diet of viewpoints from all relevant people on the staff. You're certainly not trying to put your thumb on the scale between options." Reviewing Judge Kavanaugh's staff secretary documents would teach us nothing about his legal views. For that, we have the 307 opinions that he wrote and the hundreds more joined, totaling more than 10,000 pages of judicial writings. We also have more than 17,000 pages of speeches, articles, teaching materials, and other materials that Judge Kavanaugh attached to his 120-page written response, which I think it was a judiciary's questionnaire, was probably the most robust questionnaire ever submitted to a Supreme Court nominee. We also have more than 480,000 pages of emails and other documents from Judge Kavanaugh's service as an executive branch lawyer. This is 500,000 pages of paper, more than the last 5 confirmed Supreme Court nominees combined. In addition to not shedding light on Kavanaugh's legal views, the staff secretary documents are very sensitive to the executive branch. Let's emphasize that word sensitive. These documents contain highly confidential advice, including national security advice, that went directly to the president from his advisors. It would threaten the candor of future advice to presidents if advisors knew their advice would be broadly disclosed. Senators have more documents for Judge Kavanaugh than any nominee in Senate history. Democratic leaders insistent on getting staff documents, I think, was a way of not having this hearing take place at this particular time. So can I proceed, members of the Democratic Caucus?
Mr. Chairman, if I may be recognized for one final
After
point.
you're done, can I proceed to my opening statement?
I'll defer to my colleagues, but just as a point of information, we sent a letter to you, Mr. Chairman, 7 days ago regarding the committee confidential nature of the documents and asked that they would not be designated committee confidential. As another point of information, it is my understanding there are 6 to 7 million pages of documents regarding this nominee. And it is my understanding, with all due respect, Mr. Chairman, that you've only requested 10 to 15% of the total. I appreciate that there are a lot of pages of documents, but we have to have this conversation in the context of the total. and the fact that we've only been given, by your request, 10 to 15% of those documents. And my final point is this.
I got it.
This is a hearing about who will sit on the highest court of our land. This is a hearing that is about who will sit in a house that symbolizes our system of justice in this country. And some of the most important principles behind the integrity of our system of justice is that we have due process and we have transparency. That is why we have public courtrooms. That is why we have requirements in courts of law in our country, that there will be transparency, that both parties will be given all relevant information. We can argue then as to the weight of the documents and the significance, but not as to whether or not they're admissible. So I object. I ask that we renew and revisit Senator Blumenthal's motion to suspend, or my motion to postpone this hearing. Thank you.
Okay. Thank you.
Mr. Chairman.
I appreciate the courtesy of the Democrats for me to proceed.
May I just have one last opportunity?
Please go ahead.
On my motion. Thank you, Mr. Chairman.
Please go ahead.
I appreciate your giving me the floor. I've made a motion that is properly before this committee. The chairman said earlier that he has never been through a confirmation process like this one. The reason is that no administration in the past has engaged in this kind of concealment. That's the reason, very simply. It is not the chairman's doing, necessarily. It is this administration that has concealed and hidden documents from us and from the American people. And so I renew my motion that we adjourn so that we can access the documents we need, review them in a deliberate and thoughtful way. Much has been done for colleagues in the past when they have requested it, and as is required under Rule 4 of our rules, there is no requirement that we be in executive session to follow this rule, Mr. Chairman. And I respectfully ask that we follow our rules, that we proceed in accordance with those norms. And I know the chairman has great respect for open government, for whistleblowers, for sunlight as the best disinfectant. We need some sunlight in this process. Thank you, Mr. Chairman. And I again renew my motion to adjourn, which has been seconded by Senator Whitehouse.
Denied because we're not in executive sessions. I will proceed with
Mr. Chairman, before you proceed, I'd just like to make one correction. There is a misconception as to what White House staff secretaries do. And in fact, two past staff secretaries, Todd Stern and John Podesta, wrote an op-ed in July 30, 2018, Washington Post titled, "Staff Secretaries Aren't Traffic Cops. Stop treating Kavanaugh like he was one." And in fact, Judge Kavanaugh himself has acknowledged the importance of the time that he was White House staff secretary. So why, Mr. Chairman, you and the others on your side keep saying that this was a kind of a nothing kind of a job, nothing could be further from the truth. And this is why we are so adamant about requesting these documents that the judge himself, the nominee himself, has said were among the most formative time of his adult life. Thank you, Mr. Chairman.
Of course, that's why we have this hearing. Judge Kavanaugh.
We don't have the documents.
Judge Kavanaugh will have an opportunity to answer every question about his role in almost anything he's done in his lifetime, I assume.
Mr. Chairman. Mr. Chairman, may I be recognized, sir?
Yeah, will you be the last one, or do you want to go on all afternoon?
I can't speak for my colleagues, but a lot of people I have a lot of respect for on this committee, especially some of the new folks. I just want to answer in the most plain-spoken way I can possibly do. Is we're expected to evaluate a nominee who has a vast record. And if you look, and a lot of numbers have been cited, 10,000 here, 40,000 here, 100,000 here, but in the entire body of his record, sir, we've only have 10% of his record we've been able to evaluate. 90% of it has been withheld from senators, 90% of his record. So we're asking to evaluate a candidate, to have intelligent questions and insights into his record, but we only have 10% of that record. We can go on and on about the numbers of documents, 100,000, 10,000, but the fact is we are about to proceed with a historic hearing. We're about to proceed towards having a hearing on someone having a lifetime appointment on the most important court in the land that will effectuate so many of the areas of American life, from civil rights to women's rights to access to health care. All of this stuff is being decided, and we're going into this only having 10%, access to 10% of the body of work of this man's career. That seems to me just common sense. 90% is missing right now. Just common sense says we should have access to thoroughly evaluate this person. We're not asking for anything out of the ordinary. Other candidates have come before. People can talk about tens of thousands here, 100,000 here, but we've gotten far more for every Supreme Court justice that has been mentioned here, far more than just 10%, just a scan a bit. My colleagues talk about what our duty to the American public is. Our duty to the American public is to evaluate a candidate on their body of work, but we're not even getting released that. And why? Because some political person, not a person who holds public office, not because, I mean, it's unprecedented to think that this committee has ceded its role to a partisan outside lawyer. And so here we're about to go forward with just 10% of this person's record to evaluate, to base our questions on, to investigate. 90% is being withheld. Just common sense would say that that's not fair, that's not right, it undermines our ability to do our job. It is just plain wrong.
One of the Senate's most solemn constitutional duties is to provide advice and consent to the President on the nomination of Supreme Court justices. We're here this week to hear from Brett Kavanaugh.